I call David Clendon.
Thank you, Mr. Chair. Before addressing some of the key clauses of the bill in this part, I'd just like to make two sort of more general comments. The first one being that we do have considerable sympathy for our Labor colleagues' view that this legislation unfortunately doesn't go as far as it might. There are things missing from this which could usefully be put in here. The primary legislation is now about a decade old. Coronial legislation is not something we want to be coming back to too often. We all want a system that functions well, effectively, meets the needs of New Zealanders, and for that reason we will be supporting, I think, most if not all of the Labor Party's proposed SOPs, which do for the most part reference a later part of the bill. So the other general comment I'd make is deriving some comments from the Chief Coroner's submission to the Select Committee. And in it, the coroner said that at the outset she notes that the amendment bill does impose some further requirements, some further obligations on the coroner, on the Chief Coroner, and indeed on other coroners. And she points out that the ability of her office, my office, the coroner's office, to meet these requirements, quote, is dependent on sufficient resourcing. She goes on to say the Office of the Chief Coroner staff consists of a judicial support manager and a personal assistant. And there are two, at that point at least, two recent law graduates responsible for legal research for the Chief Coroner and for the 16 coroners nationwide. Comments along those lines I have heard from all of the coroners I've spoken to personally, that they operate in an under-resourced environment. There probably ought to be two more of them, and that they all need more administrative assistance in order to do their work in a timely fashion. Because after all, as the point's been made, nobody actually wants to be involved with a coroner, and it's incumbent on us to endeavour to make sure we get the most effective means we can, that they can do their work as swiftly as possible and get the outcomes. So to speak to some of the specifics in this first part of the bill, one of the first matters that came to the committee's attention was the conversation or a discussion about the relationship between the coroners and the police, because I think it's not a well-known fact that the coroner's office have no particular investigative resource of their own. They are completely reliant on New Zealand police to go out and do the investigations for them. The original drafting of the bill had it that the Commissioner of Police must cause to be made all investigations that are reasonable and necessary to help to achieve the purpose of the Act and to investigate as directed by the responsible coroner. Now, the coroner came back, the Chief Coroner again, was concerned at the use of the word reasonable. She felt, and the committee in turn agreed, that the original wording actually gave too much discretion to the police to say no to the coroner, to refuse effectively to carry through investigations which the coroner might have thought were necessary and called for. And I do think that the wording that has replaced it now, it still allows for the Commissioner of Police to object if he or she thinks that a requirement from the coroner, a request from the coroner is unreasonable or unnecessary. Then there is a process where the Commissioner might go to the Chief Coroner, make the case, and if ideally they'll come to some arrangement whereby the needs of both will be fulfilled. Again, to me, this whole concern about that relationship seems to rest on a resourcing issue that does require significant resources over time for police to investigate well to the standard required by the coroner, particularly when an inquest is occurring. It would seem to me that they're put in this unfortunate position of the coroner's office and the police having to have the language nailed down fairly tightly, because I don't believe there's any sort of inherent opposition from within police to follow the reasonable instructions of the coroner's office, but there is a concern that on occasion they may well lack the resource to do that, given the demands that are placed on them, the obligation they're under to prioritise everything they do. So I think that was reflective, as I say, of the fact that too many of the functions and purposes of our justice systems throughout are being constrained by lack of resource, and it's reflected in the changes made here.
David, I call Dennis O'Rourke.